The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is Curlee versus Johnson, and we'll hear from the appellant.
Good afternoon, Mr. Chief Justice and Associate Justices. My name is Jason Burton from the Wake County Bar, and together with my co-counsel, excuse me, Michael Maurer, we represent the plaintiff appellant in this case, Ricky Curlee, as well as his mother individually and as the guardian ad litem. I will be delivering the argument today for the plaintiff appellant and would ask to allocate 25 minutes to the initial argument and 5 minutes to rebuttal. As the court knows, we are here as a result of a dissenting opinion by Judge Christopher Brooke in connection with the April 7th, 2020 opinion from the North Carolina Court of Appeals in this case. The underlying case, which was filed in Johnston County Superior Court, arises out of a March 17th, 2017 incident where plaintiff Ricky Curlee, who was 7 years old at the time, was bitten in the face by a dog that was owned by tenants Stacy Tallada and Raymond Craven and housed on a property that was owned by defendant Johnson. Following the close of discovery in the trial court, Mr. Simpson moved for summary judgment on behalf of defendant Johnson, which was granted by Judge Stephen Futrell on April the 10th of 2019. Thereafter, we took an appeal to the Court of Appeals, and the April 7th, 2020 majority opinion upheld the trial court's grant of summary judgment. It is the plaintiff's belief, as set forth in our papers and documents submitted to the court, that both the trial court and the Court of Appeals erred in granting summary judgment, and in doing so, ignored competing evidence proffered by the plaintiff, resolved factual ambiguities and disputed issues in defendant Johnson's favor. We believe that a proper application of Rule 56 would demonstrate that there are genuine issues of disputed material fact with respect to each element of plaintiff's common law negligence claim against defendant Johnson related to the dog bite at issue. As this court knows, the summary judgment standard is well established in our law. Summary judgment is only proper when the pleadings, admissions on file, answers to interrogatory and depositions demonstrate that there is no genuine issue of material fact. Summary judgment is a drastic remedy that should be granted only when the truth appears quite clear. It is rarely appropriate in a negligence case and rarely appropriate when matters of intent and knowledge are at issue, as they are in this case. Importantly, the court is entitled to consider uncertified or otherwise admissible documents on a motion for summary judgment to the extent not challenged by a timely objection. It's our belief that if this standard was properly applied, summary judgment would not have been granted in defendant Johnson's favor. But as set forth in Judge Brooks' opinion, the majority opinion of the Court of Appeals shaded facts and law in a manner that was advantageous to defendant Johnson in arriving at a conclusion that we do not believe is supported by the law. The 2004 case of Holcomb versus Colonial Associates was the first pronouncement from the North Carolina Supreme Court indicating that ordinary negligence standards apply in assessing a landlord's liability for a bite inflicted by a tenant's pet. Prior to that time, the courts tended to apply a strict liability standard that required a demonstration that the dog had vicious or aggressive propensities and that the owner was on notice of those vicious propensities. The primary Court of Appeals case that has construed Holcomb is the case of Stevens versus Covington. Under Holcomb and Stevens, the plaintiff is required to prove two elements or establish that there are genuine issues of material fact on two elements in order to withstand summary judgment. Those two elements are that the landlord had knowledge under a knew or should have known standard that the dog had dangerous propensities, and number two, that the landlord exercised sufficient control over the premises to remove the danger posed by the tenant's dog. In order for the court to adjudicate this motion, I believe it's appropriate for the court to have a full factual understanding both of Johnny the dog in this case and of defendant Johnson, the professional landlord in this case. Although the Court of Appeals opinion seems to simply reference the idea that Johnny was a mixed breed dog and the fact that Johnny had previously had an incident with another child in October 2014, the Court of Appeals opinion omits necessary facts bearing on the dog's characters and propensities. As testified to by Craven and Tallada, the owners of the dog and the tenants on the property, this was a mixed breed dog that was given to the tenants sometime around November of 2013. Mr. Craven testified that he thought that one of the parents of Johnny was a collie and that the other dog, or was a black lab, and that the other dog was a dingo or a collie mix. The testimony from animal control in this case has been that based on visual indicators of Johnny's appearance, they determined that Johnny was a pit bull and Labrador mix. It was described as Johnson County Animal Control as a large dog. It was described by Craven and Tallada, even in the time leading up to the October 2014 incident, as a rambunctious and excitable dog. Craven and Tallada both testified that Johnny was a safety concern for children. They had testified that they were particularly concerned because Johnny had run up to and knocked a child off their bike before while playing on the property. They also testified that Johnny would run up to and bark at every individual that came to the property, including defendant Johnson. Prior to that October 2014 incident that we referred to as the PK incident, Johnny had displayed characteristics of being rambunctious, of chasing after children on the property, and even knocking children off of bicycles. On October 13th of 2014, roughly 5.5 months before the bite involving Ricky Curlee, there was another incident on the property involving a minor child. Now, the Court of Appeals, in discussing the PK incident, said that there was not sufficient evidence to determine that it was a, quote, attack. We believe that in reaching that flawed conclusion, they ignored evidence from Johnson County Animal Control, as well as other deposition testimony related to that incident. Now, while Ms. Tallada has described the circumstance as a nick, her deposition testimony indicates that it was a bite that required her to take the child to the hospital. As a result of that bite, the hospital called Johnson County Animal Control and reported the bite. In the deposition of Chad Massengale, he described that a bite is characterized as breaking the skin. He acknowledged that the child required a trip to the ER. He acknowledged that the skin was broken, and he documented the October 13, 2014 incident accordingly. As a result of that incident, Johnny was quarantined for a 10-day period of time with Johnson County Animal Control. During that quarantine period, it was determined that he was not up to date on his rabies shots. And once the 10-day quarantine period passed, there was a discussion between the dog owners and Chad Massengale and others at the Johnson County Animal Control, wherein the tenants were advised to erect beware of dog signs about the property and to begin tethering Johnny by way of a chain whenever children were around and on the property. Now, the testimony of Mr. Craven is that beware of dog signs were posted in 3 or 4 different places leading up to the property, including the gate, which provided the only means of ingress and egress to the property. There is a photograph in the record on page 327 that shows the exterior view of the home owned by defendant Johnson and being leased to Craven and Tallada during the relevant time period. There is a fence that comes all the way up to the gravel road, and there is a narrow opening there at the gravel road. Following the release from quarantine, Mr. Craven and Ms. Tallada thought it was appropriate to chain Johnny to the post right beside the driveway. In part, that was so that other individuals would know that that Johnny the dog was on the property. Now, Mr. Craven, in speaking about Johnny and Johnny's presence on the property, said in his deposition, which is page 276 of the record, they only dared to come so close, they did not dare come in my yard. That was because Johnny, the rambunctious, excitable guard dog, was chained right there at the entrance to the property. Defendant Tallada admitted in this case in her deposition, which can be found on page 219 of the record, that Johnny was a safety concern to she and Raymond Craven following the October 2014 bite. Equally important to the court's understanding of the issues is understanding who Defendant Johnson is. This is not a one-off property owner that entered into a residential lease agreement. This is a professional landlord that has owned residential rental properties and managed residential rental properties in and around Johnston County for more than 20 years. His deposition testimony was that at any given time, he has as many as 100 rental properties in and around Johnston County. He testified that as a career landlord, he's familiar with the dangers that can be posed and the nuisance-related issues that can be posed by a problem animal on a property. For that reason, he announced in his deposition his self-defined standard for determining whether or not it's appropriate for a dog to remain on the property. His testimony was the dog cannot be a nuisance to any of the tenants or property owners. It cannot destroy my property, of course, and be, dangerous to anybody else that's in the area. He acknowledged that he retains control over pets that are kept by tenants at his properties, and further acknowledged that he has exercised that control on a number of occasions to either remove a barking dog or remove a tenant entirely from the property.
You've mentioned quite a bit, counsel, about the fact that there has been discovery testimony that I'm assuming, based upon what I've read and what I've heard you say in your introduction, that this discovery testimony ought to be considered as lending towards genuine issues of material fact. How should we treat, as a court, this aspect of the admissions or lack thereof in terms of one party of the couple responding as she did, and then the other of the couple not responding at all, with the classic discovery treatment therefore being that such an admission would be deemed to have been made? And with all of that, please plug in there as well how that would operate against, if at all, against the landlord here, in light of the fact that there is some case law that would say that such admissions would not be deemed to be appropriate against that party.
Absolutely, Justice Morgan, and thank you for raising that issue. We start with the proposition that Rule 36 of our North Carolina Rules of Civil Procedure demonstrates that a Rule 36 admission is conclusively established unless the trial court on motion permits withdrawal or amendment of the admissions. Now, in this case, requests for admissions were served on Defendants Craven and Tallada with the filing of the complaint. Defendant Tallada, Stacy Tallada, went through and answered the request for admissions with handwritten responses and produced those in response to the questions. Defendant Craven testified in his deposition that when Ms. Tallada filled out those responses, they had a candid conversation regarding the requests. They did their best to make sure those requests were answered truly and appropriately, and they submitted her answers following their efforts to answer them. In Ms. Tallada's responses, she admitted that she had told Defendant Johnson shortly after the October 13, 2014 bite involving PK of the incident itself. Now, Mr. Craven, on the other hand, did not submit responses to the request for admissions. He acknowledged in his deposition that he was required to, but said he didn't want to because he didn't believe that his dog was a pit bull. Notwithstanding his failure to respond, that failure to respond is deemed to be an admission pursuant to Rule 36 in the North Carolina rules. Tying that back to the Rule 56 standard, this court is entitled to consider admissions on file in connection with the determination of whether there's a genuine issue of material fact.
Doesn't your argument on this point essentially assume that Ms. Tallada and Mr. Craven's admissions are admissible in evidence against Mr. Johnson?
Justice Irvin, it relies on the idea that they are admissible in evidence in some form or fashion.
Well, what is your authority for saying that an admission by party A is admissible against party B in the absence of a showing of agency or something to that effect?
As an initial matter, Justice Irvin, we have never taken the position that the request for admission evidence is binding, definitively binding.
I mean, I'm not worried about binding. Your argument seems to me to hinge on the idea that the admission by the two owners of the dog is admissible against Johnson, and that's what suffices to create an issue of material fact. I mean, I think that's your argument, isn't it?
That is in part our argument. Our argument is that that is but one factor that gives rise to a genuine issue, but to
basically it is true, isn't it, that for purposes of summary judgment, the information is considered in determining whether a genuine issue of material fact exists it has got to be admissible.
That is correct, Your Honor, and we don't disagree.
What renders this evidence admissible as to Mr. Johnson?
At a bare minimum, Your Honor, it's admissible for impeachment purposes, both as to Defendant Craven and Defendant Johnson.
But don't you have to have it admissible for substantive purposes in order for it to create a genuine issue of material fact?
It also constitutes an admission by a party opponent, that being Defendant Tallata herself. We believe
that my point is, I mean, the thing I'm interested in pursuing, I understand it's admissible against, that it would constitute an admission by a party opponent regardless of whether it appeared in the context of a request for admission. But how is this evidence admissible against Mr. Johnson?
It provides some evidence of his notice of the prior acts of Johnny the dog and his knowledge or notice that there were dangerous propensities posed by Johnny remaining on that property.
How is it any different than a hearsay statement by Ms. Tallata or Ms. Craven?
I'm not sure if I understand the question.
I mean, you have to, I mean, in order to show, your argument assumes that an evidentiary admission by Ms. Tallata or Ms. Craver is admissible for substantive purposes against Mr. Johnson, doesn't it?
Your Honor, our position is that the request for admission evidence is admissible in the trial of this matter, both as an admission with respect to that Defendant Tallata and with respect to the notice element regarding this Defendant Johnson.
Can you cite me anything that says that?
I don't have any cases with me right now that stand for that proposition, but it's hard to envision a scenario where a jury impaneled in Johnston County could hear that evidence with respect to Defendant Tallata, who remains a defendant in this case, but would somehow not be privileged to hearing that information as it relates to Defendant Johnson.
I mean, don't we admit evidence for limited purposes all the time?
Your Honor, Justice Irvin, that is absolutely correct, and we believe that to the extent that a limiting instruction would be appropriate, that the trial court could make that determination in the trial of this case upon remand.
And would the limiting instruction be that you can't consider that statement for the truth of the matter asserted, i.e. that I told Mr. Johnson about the prior dog bite?
I believe that that would be a matter that the trial court would have to determine based on the evidence and the manner in which that testimony is presented at trial. But I think it's important for the panel to understand our case does not depend on that admission being binding upon Defendant Johnson.
I'm sorry to repeat myself, but I think it's clear you're not contending that it's binding. What I'm trying to figure out is whether it is admissible and can be considered for that purpose at all. I mean, those are two different things. I think you're saying the second. I'm trying to understand what's your basis for that assertion.
And again, to speak to that directly, we do believe that that would be admissible. It would be admissible in the trial of the case as a admission by a party opponent. It would be admissible from an impeachment standpoint, and it would be admissible to test the credibility of Defendant Johnson's testimony. We have to remember that Defendant Johnson, in this case, initially authored interrogatory responses saying, "I've not been on that property in many, many years." He then changes his response to say, "I haven't been in the house in many, many years." He now admits through subsequent discovery that he's been on that property 12 times a year throughout the entire 17 years of the tenancy. We believe that he has credibility issues, and that those credibility issues should be fleshed out in the trial of this case, including his response and his defending himself with respect to the request for admission evidence that is currently at issue. In addition to the request for admission evidence, the history of Johnny as a dog, the history of Defendant Johnson coming on that property once a month throughout the entire tenancy, including the time period between the October 2014 bite and the March of 2015 bite, we believe that there is more than ample evidence when applying a new or should have known standard to state a proper cause of action against Defendant Johnson to withstand summary judgment. We, on the plaintiff's side of this case, hired an institutional property manager named Daryl Greenberg to provide industry standard testimony regarding a landlord's keeping of a dog under North Carolina law. That testimony has been unrebutted by the defense in this case. His testimony was that it's incumbent upon a landlord to ask appropriate questions when they realize that a dog is being kept on the property. In addition to asking appropriate questions, it's his testimony that it's the duty of a landlord to ask further questions when they are on notice of a change in condition at the property with respect to the keeping of an animal. Again, this is a man that came on the property once a month throughout the entire term of the tenancy. Though the Court of Appeals would suggest that he came to the cul-de-sac, that is not consistent with the testimony offered by Johnson, by Craven, or Talata in this case. Defendant Johnson has admitted that he became aware of the beware of dog signs when he came back to the property following the October 2014 PK incident, but that he never even asked a question as to why those appeared when they hadn't been there in the initial 15 years of tenancy. He didn't ask a question about why the dog was being kept in a different manner than it was in the first 15 years of the tenancy. Mr. Greenberg's testimony is that those changes in conditions would be a flashing red warning sign for any landlord to further investigate the circumstances existing on the property. It's our belief that Defendant Johnson in this case simply ignored that which was right in front of him the entire time. The very dog that would have run up to him and barked at him when he arrived at the property. The very dog that knocked children off bikes prior to the October incident. The very dog that sent a child to the hospital for stitches in October of 2014. And the very dog that prompted the placement of the beware of dog signs throughout the property. Now, we recognize that control was not a major issue in the Court of Appeals' primary opinion, but it was an issue that was raised by Judge Brooke in his dissent. And we would simply, quickly before turning it over to Mr. Simpson, the written lease agreement in the Holcomb case provided that the landlord could remove an animal that was a nuisance or a disturbance, or if the landlord simply determined that it was undesirable. We do not have a written lease in this case because Defendant Johnson's testimony is the written lease covered the first year, but he does not have a copy of it. Since that time, the Talata and Craven have been renting the property on a month-to-month basis pursuant to a month-to-month tenancy. A review of the case law considered by the Holcomb Court in finding that the landlord had adequate control to remove the danger posed by the animal cited to a case that talked about the landlord's inherent power to end a month-to-month tenancy. Defendant Johnson retained that control under North Carolina law, but more importantly, he testified that he has used that control to remove problem animals from other properties in the past and to resolve issues related to disputes among tenants related to pets that are being kept on the property. We believe that there are genuine disputed issues of material fact with respect to both primary elements in this case, the element of defendant Johnson's knowledge and the element of defendant Johnson's control related to the property. Again, with respect to knowledge, it is a new or should have known standard. What should defendant Johnson have known through the exercise of ordinary care at that property? If he would have asked questions that our industry standard expert says he was required to ask, he would have known and the dog could have been removed. I'll now turn it over to Mr. Simpson.
Thank you, counsel. We'll hear from the appellee.
Thank you, Chief Justice Newby, members of the court. Good afternoon. My name is George Simpson, and I represent defendant appellee John Johnson, who is the longtime landlord of our co-defendants in this case, Raymond Craven and Stacy Collada. At issue in this appeal is whether, on the facts before the court, someone who sustained a dog bite injury can recover not from the dog's owners, Mr. Craven and Ms. Collada, but from the dog owner's landlord, Mr. Johnson. Based on application of North Carolina's substantive law governing landlord liability to third parties, the answer to that question is no. In addition to the substantive law governing landlord liability to third parties, the Court of Appeals decision should be affirmed on procedural grounds based on plaintiff's failure to contest in their new brief one of the two essential elements for landlord liability, namely the requirement that a landlord have specific contractual or other control over a tenant's activities with respect to pets. The accident in question occurred nearly 6 years ago now in March of 2015. And in the first iteration of this lawsuit, which was filed in 2016, only one defendant was named, and that was Mr. Johnson. And in that lawsuit, plaintiffs sought to recover both compensatory and punitive damages for Mr. Johnson for his alleged ordinary negligence and his alleged willful and wanton negligence. And after a period of discovery, Mr. Johnson moved for summary judgment. And on the eve of that hearing, the plaintiffs took a dismissal and thereafter, about 10 months later, refiled. This time naming not solely Mr. Johnson as a defendant, but also the two tenants, Mr. Craven and Ms. Collada. The tenants have proceeded pro se in this matter. They have not retained counsel and they did not file answers to the complaint. And plaintiffs obtained an entry of default against both of the tenants in this case. The two tenants have rented for Mr. Johnson a plot of land in rural Johnston County that abuts Interstate 40 since shortly after the constructed in approximately the year 2000. And at the time of this incident that we're here about today, they had lived there largely without incident for about 15 years. And during those roughly 15 years, the tenants had a number of dogs, and it is undisputed that before the arrival of Johnny, the tenants had not had any prior incidents with any of their dogs that they lived with on Gower Circle. After discovery was complete in the second go round in the lawsuit, we renewed our motion for summary judgment, which was heard by Judge Stephen Futrell in Johnson County Superior Court, and that motion was allowed in full. The motion was a broadly motion. I know the court has it in the record on appeal, but I did want to highlight exactly what Judge Futrell's motion allowed. It allowed summary judgment on the basis of our motion that defendant was not negligent, did not breach any duty owed to plaintiffs, did not have actual or constructive knowledge of any dangerous propensity of Johnny. There was no admissible evidence that the dog was a dangerous breed. The damage was not reasonably foreseeable to Mr. Johnson. Mr. Johnson did not proximately cause plaintiffs' alleged damages, and defendants' actions were not grossly negligent or willful and wanton and did not give rise to any claim for punitive damages. And that motion was allowed in full, as I say. dissent.
Did you allege in your motion that there was, that the minor plaintiff provoked the dog?
We did not allege we did not pursue a contributory negligence claim, if I'm understanding your question correctly. In other words, we did not allege that.
That's a way to understand it. I think we're on the same page.
We were not blaming the 7-year-old boy exactly. I mean, we do say that, I mean, the facts, just the objective facts are that he walked within the radius of Johnny's tether. And so, I mean, that is just the simple fact. If he had not done so.
The basis that you presented this matter to the trial court on involved a series of allegations, none of which had to do with how did the actual bite occur.
The basis of our motion was focused on Mr. Johnson's actions, or you know,
lack of knowledge, lack of control, that kind of thing. That's what was the issue in the trial court, wasn't it?
That's correct. And Judge Futrell's order did not. It was
didn't specify ground. He didn't specify ground. Doesn't have to.
He specified all of the grounds that I just read, which is what was expressly contained in our motion. And those grounds focus on Mr. Johnson's actions, his alleged negligence,
okay.
And did not contend that Ricky, the minor, had provoked this incident himself.
Okay, thank you.
Does the discovery response here by all of the parties that were deposed or otherwise submitted questions to which to respond, should that have figured into whether or not there was a genuine issue as to material fact, and if so, how much?
Your question is, should the trial court have considered all of the discovery that was submitted to the trial court in connection with the motion?
Yes, including the disputed admissions, whether they were admissions by way of lack of response or whether they were by way of actual response, and how they would operate against the opposing party.
It's my understanding that Judge Futrell did, in fact, he was presented with the request for admissions. That argument was made, which was addressed with Mr. Burton a few moments ago. That issue was made aware to Judge Futrell, and obviously he did not place weight on those requests for admissions, and concluded that the handwritten responses of Ms. Tallada, which I'll talk about in further detail in a moment, and deemed, what I'll call the deemed admissions of Mr. Craven for failing to answer them in the first place, did not prevent the entry of summary judgment in Mr. Johnson's favor in this case.
Since that's an issue before us, was the trial court correct in not considering those purported admissions?
Yes, it's our position that the trial court was correct, that the request for admissions, the deemed admissions of Mr. Craven and the handwritten response of Ms. Tallada, as I say, should not have barred summary judgment in favor of Mr. Johnson.
And can I just follow up on that? Did the trial court have an obligation to look not only at the admissions, but the deposition testimony of those two witnesses about how they sat down and tried to answer those questions?
We did submit deposition testimony of both Ms. Tallada and Mr. Craven, and those materials were before the court. I believe they were addressed to some extent in oral arguments and in the briefs. And it was pointed out to the trial court that the deposition testimony, the under oath with Mr. Craven and Ms. Tallada, confirmed that they had not provided Mr. Johnson with any information or notification of the PK incident, the first incident, if you will, which happened about 5 months before the Curlee incident. So that information, that testimony was in front of Judge Futrell, and I believe he considered it. And I think that their deposition testimony does help put into context how to take these requests for admission responses or lack of responses from the pro se defendants. I mean, when put under oath in a deposition, their testimony was that they had not provided notice. So the plaintiffs would like to, they are contending, as I understand it, that, for example, Mr. Craven's failure to answer the request for admissions about what Mr. Johnson knew and when he knew it should bar summary judgment for Mr. Johnson. Well, I mean, the absence of any response at all from a pro se defendant shouldn't put Mr. Johnson in that position when their own sworn deposition testimony makes it clear that that's not in fact true. The dissent at the Court of Appeals focused on one issue and one issue only, and that is allegations of Mr. Johnson's ordinary negligence. The dissent did not address or touch on in any way the claims for willful and wanton negligence that would give rise to punitive damages, and it is our position that under Appellate Rule of Procedure 16B, that the dissent did not address that punitive damages issue means that Judge Futrell's order at the trial court level is the law of the case. With respect to the incident itself, Ricky was bitten by Johnny the dog while Johnny was tethered by its owners outdoors on a chain on property bearing 3 beware of dogs signs. Ricky had been visiting with the tenant's children prior to this incident, and his parents had both visited the property a couple of days before this happened. The children of the Curlee family and of the tenants, what I'll call the tenants family in this case, Mr. Craven and Ms. Tallada, had become friendly riding the school bus together and wanted to play outside of class. And so Ricky's parents came over to visit with the tenants, and they visited at their property. The parents visited at the tenant's property. They saw Johnny the dog, heard Johnny the dog. They saw the beware of dog signs with their own eyes. And Ricky's parents themselves deemed it safe and appropriate 2 days later to allow Ricky to go to the house to play alone, unsupervised by his parents. When it came time for Ricky to leave and go home, the evidence in the record on appeal is that Ricky walked inside the radius of Johnny's chain and aimed a toy gun at Johnny's head. And it was then that he bit Ricky. And in response to that incident, the tenants immediately had the Johnson County Animal Services put Johnny down. You've heard about the PK incident from 5 months before. I would just note that incident was of a different kind than the incident involving Ricky Curlee. The evidence in the case is that it was a nick on PK's head while the boys were roughhousing and wrestling with a dog, and it was nothing on the order of what happened to Ricky Curlee 5 months later. After that incident, Johnny was taken by Animal Services for 10-day quarantine, as is required under the law. And he was checked out and deemed not to be either dangerous or potentially dangerous under state statute and Johnson County ordinances, which govern what to do when you have a quote unquote dangerous or potentially dangerous dog. Chad Massengill is the director of Johnson County Animal Services, and he was deposed in this case. And he testified that he viewed this incident, the first incident, the PK incident, as a minor incident. That's his word. There was a small cut or nick on PK's head, but it was nothing like, as I say, what happened to Ricky several months later. Mr. Massengill, after the 10-day quarantine, returned Johnny to the tenants deemed it safe for them to continue having Johnny, even though the tenants had children of their own who lived at the house, and placed none of the statutory restrictions on their maintenance of Johnny that would be required if Animal Services had deemed him to be a danger to folks. Despite not placing any of the statutory requirements on the tenants, there was a discussion between Mr. Massengill and the tenants about steps they could take as responsible dog owners to try to protect folks who visited their property. And it was then that the tenants erected 3 beware of dog signs and began tethering Johnny when guests were on the property. Mr. Massengill testified that he viewed that in his experience and in his role as Director of Animal Services as evidence of a responsible dog owner. There's been some discussion about Johnny's breed. A little bit about Johnny. At the time of the incident, he was approximately 1 year and 4 months old. He'd been given to the tenants by a friend from a litter of puppies. And Mr. Craven understood that Johnny was a mixed breed with a black lab father and a mother who looked like a collie or a dingo. Mr. Craven testified that when he took Johnny to the vet had indicated that he looked like a black lab and never mentioned anything to Mr. Craven about Johnny having any pit bull in him, as has been alleged by the plaintiffs in this case.
In terms of talking about the summary judgment, if I can go back to that legal issue, we're pretty familiar with the facts, but in terms of the summary judgment aspect of this, of course, opposing counsel has mentioned 2 fairly common and established aspects of summary judgment when it is not appropriate. One is not appropriate typically in negligence actions and otherwise not typically available where intent or knowledge is at issue. And of course, intent or knowledge here is what we're concerned about as to what the landlord knew. Why would this be that rare case where those 2 principles don't apply?
So there are 2 cases that Mr. Burton walked through previously, the Holcomb case from the Supreme Court in 2004 and the Stevens v. Covington case from the Court of Appeals in 2014. And Justice Morgan, as you note, those 2 decisions emphasized a certain framework for establishing landlord liability in third-party situations like this. And it boils down to 2 requirements. One is knowledge, the other is control, not just the generalized control that any landlord has over property that's rented or leased, but a specific statutory or contractual control over this aspect of the tenant's activities. On the knowledge issue, the uniform deposition testimony of the many witnesses in this case all confirm that Mr. Johnson did not have actual knowledge of any dangerous propensities of Johnny before the Ricky Curlee incident.
Do you agree or not agree with your colleague's argument that it's not necessary for him to show necessarily actual knowledge, but that instead it would suffice if there was evidence from which a trier of fact could find that he either knew or should have known?
I know that the 2 cases, Holcomb and Stevens, discuss actual knowledge, and I don't know.
Stevens has some references to knew or should have known, doesn't he?
I'm sure you're right, Justice Irvin.
You shouldn't necessarily assume that.
Well, I don't have the cite right in front of me to any reference in that opinion to constructive knowledge. Obviously, I'll just defer to what that opinion says. I do know, obviously, that those 2 decisions refer to actual knowledge, and if there's references to should have known, then that speaks for itself. And then that would be the rule. But I don't have that right in front of me at this moment.
Assuming for purposes of discussion that should have known is a viable legal theory, and I'm not contending that you've conceded that it is, but assuming that that is a viable legal theory, why is there not sufficient evidence taken in the light that's favorable to the plaintiff not to permit a trier of fact to assume that your client should have known that there was a potentially problematic animal on the property in question?
As I understand it, the argument that plaintiffs make about constructive knowledge is that Mr. Johnson should have seen the new beware of dog signs and performed an investigation to determine why those beware of dog signs had been erected. And if Mr. Johnson had investigated why the beware of dog signs had been erected, it is our position that what he would have learned would not have resulted in him taking any steps to remove Johnny from the property. In other words, it gets into the proximate.
Is it your contention that there is no evidence at all that would support a trier of facts decision that Mr. Johnson, if he had investigated and discovered, that the animal control people had been out there previously, that there'd been this prior incident involving PK, all the things he says he didn't actually know, if he had found out, would that, your argument is that would not suffice to justify the decision to take action?
Well, I think that raises an interesting policy issue about how much do we want to make landlords approach the line of becoming an insurer of third parties' safety with respect to actions from the landlord's tenants. If Mr. Johnson had performed the investigation plaintiffs say he should have performed, he would have learned that the PK incident was referred to by Animal Services as a minor incident, that Johnny had been quarantined for 10 days and had been discharged, returned to its owners with none of the statutory restrictions that are required to be placed on dogs who are deemed dangerous or potentially dangerous. In other words, Mr. Johnson would have discovered that the professionals in this field charged with making designations of dangerous or potentially dangerous dogs had determined that Johnny wasn't either of those things. He would have learned that in response to conversations with Animal Services, the tenants had taken voluntary but not required steps. They went above and beyond, in essence, by tethering Johnny, by erecting multiple beware of dog signs. That he would have learned that the tenants had invited Ricky's parents over to meet them on their property to see Johnny, to hear Johnny, and that the parents had determined that it was safe to send their son up there unsupervised. And with those facts, based on this hypothetical investigation, what else should a landlord have done? We submit that Mr. Johnson, if he had learned these facts, would not have been legally obligated to have the tenants remove the dog from the property, and that it would have been fine for him to have allowed the tenants to keep the dog on site.
Just along these lines of what this landlord might have done, and I know this was offered in the dissenting opinion to address the control issue, but it appears from the quotation we have from the deposition testimony that this landlord talked about how if he understands there's a complaint about a dog that his tenants are keeping, if they can't stop the dog from barking, if there's any reason to believe the dog's a nuisance, then he's asked in the past, he's asked people to solve the problem and had people move. So it seems that at least his own testimony suggests that when he's aware that there's an animal on the property that's a nuisance, he's taken action.
Yes, thank you for that question, Justice Earls. The quotation, it is our position that the quotation in the dissent lacks important critical context. If you go to that testimony in the record on appeal to see the full, there's several pages of deposition testimony leading up to the quote from the dissent. And it is clear that the questions and answers were focused on how Mr. Johnson handles tenants with dogs in crowded townhome areas where you've got one unit attached to the next unit, as opposed to how he treats tenants out in the country, like Mr. Craven and Ms. Talata were. They lived on a plot of land, an acre or more, out on the side of Interstate 40. When you have the full context of that deposition testimony, it is clear that it stands for the opposite proposition from what the dissent relied on it for. That it stands for the proposition that Mr. Johnson does not exercise the same type of control over rural tenants who are out on a piece of land, who don't have a lot of neighbors right up on them, like in the townhome scenario. I have just have a few more comments. I did want to, I see I've got about 4.5 minutes. I wanted to briefly mention our pending motion to strike, the supplemental production of records that plaintiffs submitted in October of last year, that include medical records that have a different description of how the incident occurred than what was previously in the record on appeal. I wanted to note initially, our objection is based on the fact that we had oral arguments at the trial court level where this was not raised. We had 2 briefs at the trial court level where this was not raised, 3 briefs at the Court of Appeals where it wasn't raised, and the first 2 briefs in the Supreme Court where this issue wasn't raised. And then at the what amounted to the 8th brief the parties have submitted in this case in October of 2020 for these new records to be submitted at the Supreme Court level, we would ask the court not to consider those lately produced documents. If they had been introduced at the trial court level, we would have had objections based on authenticity and hearsay. In fact, I believe it's hearsay within hearsay. And so to try to address these newly produced documents at this late stage, we believe is not appropriate to put Mr. Johnson in the position of having to try to respond to these new documents at this late stage. I know
Mr. Simpson, this was why I asked about what was the nature of the issue before the trial court. It seems to me that if what happened at the time of the actual bite was not a subject of your summary judgment motion for the trial court, then what happened there isn't before us at all. So
with that,
no reason for us to be concerned about the whole question of what happened at the time of the bite. Is that wrong?
No, I agree with that. If others may disagree, I would simply point out that the records allege that one of the little boys went up and let Johnny off the leash. And if that's the case, what in the world was Mr. Johnson supposed to do to stop that?
No, but wait a minute. I guess my point is that was not a ground for your summary judgment motion. If it wasn't a ground for your summary judgment motion, do we really even need to be worried about this?
Well, I would hope that it would not be considered at all. Yes. So in that extent, no, we would submit as not something that the court really needs to be worried about. So,
okay.
And with that, I'll bring my remarks to a close unless anyone has any questions.
Thank you, counsel. Rebuttal.
Thank you, Mr. Chief Justice. A few matters that I do want to address. First and foremost, speaking to Justice Urban's question, the Holcomb decision and the Stevens decision both employ a knew or should have known standard. Part of what the Holcomb court considered on the appeal was whether the jury instruction that was given regarding the landlord was proper and appropriate given the general negligence framework that the court announced applies in this kind of a setting. The 2 jury charges at issue in that case stated One of the relevant questions was whether management associates knew or in the exercise of reasonable care should have known from the dog's past conduct that they were likely, if not restrained, to do an act from which a reasonable person in the position of the landlord could foresee that an injury to a person of another would likely result. The Stevens Court, in addressing the evidence that had been presented, rendered its decision on the basis that neither the landlord nor her husband knew or had reason to know that Rocky was dangerous. We believe that that case law clearly indicates that it is a knew or should have known standard, and we believe that based on the evidence that has been presented by the plaintiff thus far, there are genuine issues of material fact as to what defendant Johnson knew or should have known. Mr. Simpson described the kind of conversation that may have occurred between defendant Johnson and Stacy Tallada if he would have exercised the degree of care necessary to ask questions about the beware of dog sign. But what Mr. Simpson didn't mention is, on page 219 of this court's record, Stacy Tallada testified that she considered the dog to be a safety concern after the October 2014 incident. Had defendant Johnson raised appropriate questions, she would have communicated to him that which she communicated in her deposition, that the animal was a safety concern, that they were concerned primarily when children were around, and that they felt it appropriate, based on the bite that occurred in October of 2014, to take those additional steps. There has been argument in passing on the concept of waiving the control and the punitive damages issue by not raising those matters in the brief. With respect to control, the control element was certainly a subject of Judge Brooks' dissent and was certainly something that was raised in the new brief. With respect to punitive damages, this court certainly understands that a claim for punitive damages is not a separate independent cause of action under North Carolina law. It's merely an element of damage that a plaintiff may be entitled to, depending on the evidentiary showing at trial. It's our belief that the trial judge would be in the best position to determine whether the evidence rises to a willful and wanton standard, and ultimately would be able to determine whether a jury should be instructed on that issue. We are like-minded that the issue of proximate cause was never raised until the defendant's new brief in this court. We felt it incumbent upon ourselves, because the statement was made that no evidence has been adduced in discovery to contradict the inadmissible hearsay evidence of Stacy Tallada, to supplement the record to address that issue. But we do not believe that this appeal turns on the proximate cause of the event or the specifics of how the event occurred. We will simply point out that Stacy Tallada's testimony on that issue was based on inadmissible hearsay testimony. She admits in her deposition she did not witness the event, yet claims that one of her children told her sometime after the fact that Ricky Curlee had held a, quote, toy gun to the dog's head. Finally, I do just want to speak briefly to Justice Irvin's prior question about the admissibility of the request for admissions. It's our position that that's a matter that should be left to the trial court as well, because the plain language of Rule 56 allows a reviewing court or the trial court to consider admissions on file. It is only after the burden is shifted to the plaintiff, after a showing by the defendant that there's no genuine issue of material fact, that the question of admissibility becomes important. Now, the majority opinion relied on the Olds case for setting forth the summary judgment standard. And as Judge Brooke pointed out in his dissent, the line that was missing is that the court is entitled to consider inadmissible and uncertified documents and information on summary judgment if it has not been timely objected to. The Rule 36 admissions have never been objected to. No motion has ever been made to set them aside.
Thank you, counsel. Thank you, everybody. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court.